Ladies and gentlemen, good evening and welcome to Politics in the Pub. My name is Howard Bell. I'm going to be chairing the session this evening. The topic is one which is very dear to every activist's heart, every social justice practitioner's heart, every lawyer's heart, probably the heart of everybody. Do we need, should we have, should there be a Human Rights Act in Australia? Regardless of whether you call it a statutory Bill of Rights, a constitutional Bill of Rights, a Charter of Justice, whatever you want to call it. Do we need one? It's a raging debate. It's up there with the environmental debate. We're blessed tonight, though, to have two experts to help us understand the ins and outs of the case for a Human Rights Act in Australia. Chris Holley is the Activism Manager for Amnesty International Australia. He has a high level of expertise in activism techniques from his experience with the Green Party and also with the trade union movement. He's employed by Amnesty International Australia in a leadership role in organisational change. His role uses a wide range of approaches to strengthen and empower grassroots activism and strategies.
Thank you all for coming out on a chilly winter night to talk about what I think is obviously a very important issue for this country right now. As Howard mentioned, it's front page of newspapers, all variety of newspapers, as we speak. I'd like to start also by acknowledging the traditional owners of the land on which we meet tonight, the Gadigal people of the Eora Nations, and pay my respects to their elders past, present and emerging. But I do that not out of a sense of ritual. I do it because I think any conversation about human rights in this country has to start by acknowledging what a complete disaster our history of protecting the human rights of our Indigenous people has been. And the reason that it's important is because it also dispels, in acknowledging that, it dispels one of the myths that is often used, often put forward as to why we don't need a Human Rights Act. And that is the argument that Australians are an innately generous and fair people, and that we support the underdog and we look after each other. And therefore we don't really need a Human Rights Act because our culture is one that enables us to protect those rights. And it's remarkable how often that myth gets reinforced by senior politicians just as they announce the latest measure to remove or restrict the human rights of a particular minority group. We're a generous and fair people, that's why it's okay for me to lock a whole lot of people up. Because we're Australian, so the fact that we're Australian means we must be acting fairly, and it's a myth. And if an objective look at Australia's history shows that it's a myth. Undoubtedly there have been times where the Australian people have shown great generosity. But if you objectively look at our history, it's actually like most colonised countries. It's a history that's marked by occupation, by massacre, by dispossession, and by discrimination. And that history can be seen today, the effects of that history. Last month, Amnesty launched a report on Indigenous youth incarceration rates. It was a 2-year research project undertaken by Amnesty Australia as well as Amnesty's international researchers. And what that showed is that today, in Australian Aboriginal and Torres Strait Islanders, aged between 10 and 17 make up about 5% of that population. They make up 59% of the prison population in that age group, and the younger they are, the more likely they are to be locked up. So for 10 and 11-year-olds, over 60% of those in prison or in detention are Aboriginal or Torres Strait Islanders. 5% of the population, over 60% of the detained population. That shows that we can't rely on the innate goodness of our fellow citizens to protect our human rights. Because if you're in one of the vulnerable groups, you can't rely on that goodness to protect you. You need legislative protection. But Australia is capable of rising above that history. There have been points in time where Australia has actually been an international leader on human rights. In 65 years ago, the newly created United Nations proclaimed the Universal Declaration of Human Rights. And that emerged from the ashes of the horrendous World War II. 50 million people killed. The war that introduced the word genocide to our language. And the nations of the world got together and they produced the Declaration of Human Rights. It was agreed by all the countries at the time as a statement of universal human values. All nations should uphold and the rights that all people of the world should enjoy. And Australia played a leading role in developing that declaration. We were one of the 8 nations that was on the drafting committee that developed the Universal Declaration of Human Rights. And when the declaration was put to the United Nations General Assembly, Doc Evatt, who was our External Affairs Minister at the time, was President of the United Nations General Assembly and shepherded the Declaration of Human Rights through that assembly. In 1948, Australia was one of the world's leaders in human rights. I don't think we'd make that claim today, funnily enough. The last 2 decades has actually seen Australia move away from its commitment to human rights. And it's been a largely bipartisan approach from the 2 major parties that have formed government in that time. From the suspension of the Anti-Discrimination Act to allow the Howard government intervention into Indigenous communities, to the PNG asylum seeker policy created by the Rudd Labor government, which ignored the fundamental principles of the Refugee Convention, Australia's political leaders have led the charge away from human rights protections. Where once Australia championed international human rights conventions, we now routinely and deliberately breach our obligations under the Refugee Convention, the Convention on the Rights of the Child, and the Convention Against Torture. And as Louise pointed out, the response of our government's leader is we won't be lectured to by the UN about the conventions that we signed and we promised to honour. And it's also important this week in particular, I think, to note just the latest move away from those human rights protections by the Australian government, supported by the opposition. The new Australian Border Force Act came into effect on Tuesday, as Louise mentioned, and it makes it a criminal offence punishable by up to 2 years if an entrusted person, like a doctor or a teacher, publicly discloses information about what is happening in Australia's immigration detention centres. But when you combine that with another piece of legislation that's currently before the Federal Parliament, that seeks to give indemnity to private sector security guards who use force against inmates of those detention centres. And remember, the inmates of these detention centres are people who have not been charged with any offence, who have never faced a court, and yet are being held indefinitely by our government in detention. The effect of those 2 laws is that we're now in the alarming position where if a child is physically assaulted by a private security guard in a detention centre, the perpetrator of that assault will be protected from prosecution, while the doctor who treats the child faces up to 2 years in prison if he or she publicly discloses that the assault occurred. You think about that situation, it is almost impossible to think of a situation that you could design that more strongly is designed to allow human rights abuses to occur with impunity.
Yeah.
And there's a familiar pattern in the history of human rights abuses across many countries. And that pattern is that a government entrenches its power by identifying an external threat. It then stokes the fears of its people. And then it tells them that their human rights and civil freedoms make them unsafe. And that to be safe, they must agree to surrender their rights. And they must turn a blind eye when certain minority groups are rounded up and removed to camps where they can be dealt with in secret. It's a pattern that we've seen in many countries. And with that goes anyone who criticises the approach or tries to expose the abuses must be singled out and attacked as unpatriotic, as a threat to the security of the people. You have to ask them whose side they're on. Now, Australia needs a Human Rights Act to stop us going down that dark road that we are currently being led. That's the main reason we need this Act. And so the question is why? Why are we in this situation in 2015 that we're one of the few liberal democracies that doesn't have some form of National Human Rights Act or Charter? And more importantly, how do we make progress towards achieving one? Now, the arguments in favour of Human Rights Act are both strong and enduring, and Louise outlined them to you. What makes the rights outlined in the Universal Declaration of Human Rights universal is that they've been developed over centuries by many nations across political ideologies. They're neither a fad nor do they belong to a single political tradition. They're a statement of the basic rights to which all human beings are entitled, and which therefore should not be granted or withheld at the whim of governments, whether democratically elected or not. And the Human Rights Act will require the genuine consideration of those rights by governments. It will also, as Louise said, help address Australia's declining reputation and improve domestic implementation. And also importantly, and I think this is really important at the moment, it will help to create a human rights culture. Because we are being led in one direction at the moment. And what we need as a people is to develop a culture that says, no, we will not take that direction. And that's particularly important at a time when the community is being subject to overblown campaigns by tabloid media and by cynical political leaders that pay little or no regards to human rights or to accuracy. And the main benefit of a Human Rights Act is it's preventative. It actually stops human rights abuses occurring before they occur. It acts as a counterbalance to the overwhelming power of governments and corporations compared to individual citizens. By requiring public authorities and private service delivery corporations to consider human rights, many abuses will be prevented before they occur. But the question is, do we actually want a Human Rights Act? Now, I would argue that there's a very strong underlying community support across the political spectrum for a Human Rights Act. And it's not just my argument, there's evidence. During 2009, the federal Labor government set up a consultation process to see whether we should have a federal Human Rights Act. During that consultation process, it showed that there was overwhelming public support. Polls showed that over 80% of people wanted a Human Rights Act in Australia. And that was reflected in submissions to the government's consultation committee. Over 80% of the 35,000 individual submissions received supported legislated protection of rights. So with support in Australia running at better than 4 out of 5, there's no doubt that many people who vote Conservative also support the creation of a Human Rights Act. And it's likely that the level of support will continue after a Human Rights Act is introduced. In 2008, the British Equality and Human Rights Commission did a comprehensive inquiry into the effectiveness of the UK Human Rights Act after 10 years of its operation. The review included thousands of submissions, comprehensive literature review, extensive public polling. And what they found was that the effect of adopting a human rights approach has been to improve the circumstances and the lives of many people. Polling evidence shows that 84% of people want human rights enshrined in the law for themselves and their families. So that was the finding after 10 years of the operation of the UK Human Rights Act. 84% public support. And the experience was similar in Canada. Public polling in Canada showed that after 20 years of operation of the Canadian Charter of Rights, 74% of Canadians believed that individual rights and freedoms were better protected due to the Charter of Rights. So the evidence from the UK and Canada is that human rights legislation has been both overwhelmingly positive and highly popular. So we've heard the arguments in favour. So what are the arguments against? Why would we not have a Human Rights Act? Well, the main argument used by the Labor government in 2009 to justify not proceeding with the Human Rights Act, despite 80% support, was that it would transfer too much power from elected politicians to non-elected judges. That only elected politicians can be trusted to protect human rights. Now, that argument is clearly wrong on two fronts. Firstly, history tells us that elected politicians cannot be trusted to protect human rights. There is a long history, both in this country and in others, of politicians from all parts of the ideological spectrum who have shown their preparedness to trade off other people's human rights when it suited their own political interests. Australia's recent history in relation to Aboriginal peoples and asylum seekers does not inspire confidence in our political leaders as protectors of human rights. I referred earlier to the Northern Territory intervention and to the PNG asylum seeker policy introduced by a Liberal and a Labor government respectively. Both of these policies caused fundamental harm to the human rights of the people they targeted. Now, I don't believe it was coincidental that both of these policies were introduced precipitously with a complete lack of consultation and scrutiny in the lead up to federal elections and when the respective governments were behind in the opinion polls. Can anyone seriously doubt that short-term political imperatives were major drivers of both those policies and that human rights considerations were outweighed by those political imperatives? We can't trust elected political leaders to protect our human rights. Secondly, the Human Rights Act would not actually transfer power from politicians to judges. And I won't continue on that because Louise covered that pretty well. In contrast, one of the arguments, though, that the current Attorney General George Brandis argued while he was in opposition was the problem is the opposite, that in fact politicians have too much power. He argued before the last federal election, when he was in opposition, that human rights protection is best left to the common law and that too many laws made by Parliament infringe on common law rights. Ironically, he could now bolster his argument by naming several of the laws he subsequently sponsored as Attorney General as fitting into this category. This argument would see human rights protection left up to civil courts. And this approach ignores the reason why we have human rights acts and bills, which is the common law has conspicuously failed to uphold universal human rights. And one of the key reasons for this is the unequal access to the resources required to use the courts to enforce any rights that may exist under common law. Many of those whose rights are most likely to be abused have limited, if any, access to the financial and other resources required to successfully pursue a common law action. So the common law does not protect human rights unless you have the resources to access it. Finally, those who oppose the Human Rights Act argue it will create a lawyer's picnic or it will be a charter for rapists and terrorists. And Louise answered, as a lawyer, answered the question about whether it was a lawyer's picnic. But the example from both England and Canada is that there has not been a significant increase in legal, in that most actions that are brought under human rights legislation are settled by mediation. Only a very small proportion of them ended up going to arbitration and final settlement. But let's deal with the issues of terrorism, because that's the current fear campaign that we face. Every time you read a newspaper, look on social media, the government is out there telling you that ISIS is coming to get us. The argument that the Human Rights Act protects terrorists, the evidence tells us that taking away the human rights of extremists does not make it safer. It just leads to the creation of more extremists, even as we surrender our own protections from abuse by the state. So if we have strong arguments in our favour, weak arguments in opposition, strong public support for our position, where do we go from here? Well, first we have to stop relying on or expecting politicians to lead the way on human rights. We may need the politicians to enact the Human Rights Act through Parliament, but we do not need them and we cannot rely on them to build a campaign in support of such an act. It's the politicians who must be pressured to change their position. We need to tackle head-on the campaign of fear and disinformation that has been unleashed on the Australian public in a so far successful attempt to convince us that the only way to keep ourselves safe is to surrender our human rights and to trample the human rights of others. We must refuse to live our lives in fear. And we must publicly stand up for people like Gillian Triggs, who are attacked for defending human rights. And the 40 former detention centre workers who this week defied the new laws by publishing their open letters on what's happening in those centres and daring the government to prosecute them.
Yes.
We must stand with those people. We must say, we will also stand with you. We will, if necessary, take action to show how unfair these laws are and to challenge them. We must talk to our fellow citizens, explain what it is that's being surrendered and at what cost. And we must tell our political leaders that we will not follow them down the dark path that they are leading us. The issue of a Human Rights Act is not and should not become a party political issue. As I said, there is support across the spectrum for this. There are many people supporting all parties who understand the importance of human rights. Despite the best efforts of previous and current governments, there has been, I believe, there still is broad support for the Human Rights Act, and we need to build that support further to place pressure on our current and future governments to act. That will require a commitment by many individual groups of their time, their resources and their goodwill to this campaign. The coming months and years will give us many opportunities to focus on public debate on human rights, and we need to seize those opportunities and we need to go on the front foot. We need to stop being afraid of the rhetoric about national security, and we need to move it to a narrative about human rights. History has shown us that human society moves towards enlightenment, despite challenge and setback. The time has come for people of goodwill to say, we will not be drowned out. It's time for us to go on the offensive, because the campaign to protect our human rights is a campaign that we can and we must win.